Cornelius Gray watched this with the specific attention of a man who recognizes competent operation when he sees it and who had, since the water rights agreement of 1737, maintained a relationship with the Aldwell, and then the Carr household that was correct and functional, and that contained, on both sides, a watchfulness that never entirely relaxed. He called on them socially 3 or 4 times a year. He and Thomas had business dealings in the tobacco trade that were conducted with the professional respect of men who understand each other's capabilities. He was always civil to Patience. He was never warm to her. The warmth would have required him to fully acknowledge what she had done, and full acknowledgement was a thing he had not arrived at. The thing that changed everything came in the winter of 1752. Gray's elder son, Edmund, who had been managing the northern timber lands of the Gray estate, had borrowed substantially from a Williamsburg merchant house to fund an expansion of the timber operation that had not produced the returns he had projected, and the debt had accumulated to a level that the timber operation's income was not servicing adequately. Cornelius Gray, who had been unaware of the full extent of the borrowing, because Edmund had managed the information, he gave his father with the specific selectiveness of a man who knows the full picture will not be well received, became aware of it in November of 1752, when the Williamsburg merchant house sent a letter to Gray's Hall that reached the father before it reached the son. The letter specified a sum that was, by the standards of Greyfall County, large. Not ruinously large, but large enough, given the current state of the tobacco market and the reduced productivity of the southern fields that Gray had been managing with declining results for several years, to create a genuine problem for an estate that had looked from the outside like an unassailable financial fortress, but that had, like many such fortresses, been spending its reserves on the appearance of the fortress rather than its structural maintenance. Patience learned about this through the same channel through which she learned most things of significance in Greyfall County, through the patient accumulation of information from sources that did not realize they were sources. And when she learned it, she sat in the study of Whitfield Farm, which she still used as a working office despite having lived at the Carr house since her marriage, and thought about it for 3 days before she said anything to anyone. What she thought about was what she wanted. Not in the small sense, but in the full sense, the sense her father had thought about things in the last weeks of his life when he had been constructing his will, the sense that required looking at the full landscape of what was possible and choosing from it deliberately rather than reactively. She went to see Gray. He received her in the same receiving room where she had presented herself 30 years before, a young woman of 22 who had walked to his house uninvited to tell him she knew what he was doing. She was 51 years old now, and the room was the same, and she sat across from him with the same steadiness she had brought to every encounter with him across 30 years. And she told him, plainly and specifically, that she was aware of the debt situation, and that she was prepared to discuss the provision of the capital required to address it. Gray looked at her for a long time. She said the capital would come from the Carr lending operation, through Thomas as legal agent. She said the terms she was prepared to offer were reasonable, lower in their interest rate than what the Williamsburg merchant house would extend for a refinancing, and with a repayment structure that accommodated the seasonal realities of tobacco income. She said there was one additional condition. He asked what it was. She said the western boundary of the Aldwell property, which was also the eastern boundary of the Gray estate's southern fields, had been the subject of attempted adjustment in 1732 and of a legal challenge in 1735, both of which had failed. She said she wanted a permanent deed of quiet title, registered with the General Court in Williamsburg, and not only the county record, that established the boundary as defined by the 1715 deed, permanently and without the possibility of future challenge, as a condition of the provision of capital. The silence that followed was the longest silence of all the silences that had accumulated between them across 30 years of watching each other across rooms in Greyfall County. Cornelius Gray was 64 years old. He had built the largest estate in the county, and held the most legal and social authority of any private individual in its history, and had spent 30 years attempting, by various methods of varying sophistication, to acquire 15 feet of land along the western boundary of what had been the Aldwell farm, and the woman sitting across from him was the reason he had failed every time, not through force and not through greater authority, but through the specific, sustained, 20-year application of intelligence and patience, and the particular quality of a person who learns from every encounter and builds from every loss and never, under any circumstances, mistakes a setback for a conclusion. He said yes. The deed of quiet title was registered with the General Court in Williamsburg in the spring of 1753. The capital was provided. The debt was serviced. Edmund Gray's timber operation was eventually sold, at a loss, but the sale retired the remaining debt without further crisis. Cornelius Gray died in 1759, at the age of 71, leaving his estate to his sons. The Gray estate declined steadily in the decades after his death, managed by men who had inherited the property without inheriting the specific intelligence required to manage it well. The deed of quiet title held. The boundary held. Whitfield Farm, which William Aldwell had managed faithfully for 30 years, and which passed to his son after him, remained within the family, and within the boundary that Robert Aldwell had established in 1715, and that his daughter had defended across 2 decades of encounters with the most powerful man in the county, winning each one not through the authority she was not permitted to have, but through the intelligence and the patience and the specific, extraordinary competence of a woman who had understood from the beginning exactly what the game was, and had played it better than anyone around her. Patience Carr, born Patience Aldwell, died in 1774 at the age of 63, in the house she had shared with Thomas, who had died 4 years before her. In the county she had spent her entire life learning and navigating and refusing to be erased from. She left no memoir, no formal account of what she had done, because the world she lived in did not think of what she had done as something that required an account, did not think of what she had done as something at all, would have described it, if asked, as the ordinary management of a family's affairs by a capable woman, which was a description that was both entirely accurate and entirely insufficient. She left Thomas's commercial records, which were also her commercial records in every practical sense, and the legal documents she had accumulated across 40 years of building a network and defending a boundary and learning a legal system that had not been designed with her participation in mind, and using it better than most of the men who had designed it. She left the deed of quiet title. She left the prenuptial agreement that Hartley had drafted with such care, and that had been, for 35 years of marriage, the legal instrument that had given her the room to be herself within the constraints of a system that was not designed to give her room. She left, in the cedar chest in the study at Whitfield Farm that had been her father's study, and that she had used as her own for 50 years, the county land records going back to the colony's founding, annotated in her handwriting in the margins, her notes precise and her observations specific, and her understanding of the system, they recorded complete in a way that very few people in Greyfall County, and no official in the colonial administration, had ever understood. The annotations are a document in their own right, a lifetime of knowledge about how power works and how it can be met, and what it takes to hold a boundary against a person who has decided it should not be yours. The records are in the county archive. The annotations are still there, in a hand that does not identify itself, because she had not signed them, because signing them was not the point. The point was that they existed, that the knowledge they contained had been gathered and organized, and set down in a form that someone, someday, would read and understand for what it was, which was the complete and extraordinary interior map of a woman who had spent 60 years navigating a world that did not see her, and had navigated it with a precision that the world, had it been paying attention, would have recognized as the most remarkable thing happening in Greyfall County, in the entire 18th century. She was Patience. The name fit perfectly. Not the patience of a woman who waits for what she is given. The patience of a woman who knows exactly where she is going and takes exactly as long as is necessary to get there, without rushing, without revealing the destination, without ever giving the people between her and where she is going any reason to move before she is ready for them to move. She got there, she always intended to. Welcome to Dark Stories Untold. The third component was information. She understood by 1734 that the specific vulnerability of her position was not legal but personal, that the law's protections were available to her in principle, but only accessible through the actions of men who would have to be convinced to act on her behalf, and that the convincing of those men required the kind of knowledge that made convincing possible. She developed, over 3 years, a detailed understanding of the financial position of every significant landholder in Greyfall County, not through espionage, but through the careful reading of public records, and the patient cultivation of the kind of conversations that happen when a woman is present in a room, and the men in it have decided she is not listening. She knew who owed money to whom. She knew whose tobacco yields had declined and whose had improved and why. She knew which marriages had been made for money and which had been made for land, and which had been made for reasons that the parties involved preferred not to discuss. She kept none of this written down. She kept all of it in the same precise interior space in which she kept everything that mattered. Gray's revised strategy arrived in 1735, and it was more sophisticated than the boundary survey approach and more sophisticated than the marriage proposal, which was what she had expected from a man who had had 3 years to think about what had not worked and why. What he did was this. He filed a suit in the county court, over which he served as one of 3 magistrates, challenging the registration of the 1715 boundary deed on the grounds of a procedural irregularity in the original filing. The procedural irregularity was real, a minor error in the registration sequence that had been present in the document since 1715, and that had no practical legal significance but that, in the hands of a man who controlled the county court, and who could ensure that the challenge was heard by magistrates who understood the direction in which his preferences ran, could be used to have the registration voided, which would leave the boundary question open, and the 1712 survey as the most recent valid document. It was elegant. It was entirely within the available legal mechanisms. It was, if it succeeded, going to cost the Aldwell family the western boundary and the water rights and the annual income from the mill operation, which was not a catastrophic loss, but was a real one, and which would establish Gray's control over Greyfall Run in ways that would compound in their advantage over decades. Patience received word of the suit filing on a Thursday, and had written to Francis Hartley in Williamsburg by Friday morning. Hartley's response came in 10 days and confirmed what she had already suspected from her 3 years of legal study, that the procedural challenge had legal basis but was not insurmountable, and that the appropriate response was a counterfiling that placed the matter before the general court in Williamsburg rather than the county court, removing it from the jurisdiction of the magistrates, whose impartiality was not reliable. She told William what needed to be done. William authorized the counterfiling. Hartley filed in Williamsburg. The matter was removed from Gray's court and placed before the general court, where it was heard by men who did not owe Cornelius Gray anything, and who assessed the procedural question with the straightforward analysis it deserved, and found it insufficient grounds for voiding the registration. The boundary held. Gray's response to this was the response of a man who has been defeated in a specific engagement and is reassessing his broader strategy, and the reassessment took a form that Patience had not anticipated, which was the first time in 4 years that she had been genuinely surprised by him, and the surprise was educational in the way that genuine surprises always are. He came to Whitfield Farm to call on her, not on William, on her. He arrived on a Tuesday afternoon with the formal courtesy of a social call and asked, through the housekeeper, whether Miss Aldwell was receiving. She was in the kitchen garden at the time, and she came in and received him in the sitting room with the same steadiness she had brought to his receiving room 4 years before, and they sat across from each other in the afternoon light, and Gray looked at her with the expression of a man who has decided, after a considerable period of reluctance, to take something seriously. He said she was a formidable opponent. She said she had not understood them to be opponents. He looked at her for a moment and then said that was either very clever or very honest, and he was not certain which. She said it was honest. She said she had no interest in being his opponent. She said she had an interest in protecting what her father had built, and what her brother managed, and what her sister and she stood to benefit from, and that protecting it had required certain actions that had placed her in opposition to certain of his actions. But that opposition to a specific set of actions was not the same as being opposed to a person, and that she had never wished him harm or diminishment and did not now. Gray was quiet for a long time. The afternoon light moved across the sitting room floor. Outside the window, the tobacco fields ran south toward the creek and the western boundary that she had held. He said he had underestimated her. She said most people did. He said that was their mistake and not a quality she should rely on, because it was not a quality that held indefinitely once a person had been sufficiently educated. She acknowledged this. She said she was aware that her advantage in their previous encounters had depended partly on being underestimated, and that she did not expect that advantage to persist now that he understood the situation more accurately. She said she hoped that the understanding would produce a different kind of relationship between their families, one based on the accurate assessment of mutual interests rather than on the inaccurate assessment of her as an obstacle that could be managed or removed. Gray sat with this for a long moment and then said he had a proposal. Not a marriage proposal, not a boundary proposal, a business proposal. He said there was a road improvement being planned by the county committee, a new road that would run through the eastern edge of the Aldwell property, and that would, if routed as currently planned, reduce the productivity of two of their best tobacco fields. He said he had the influence on the committee to have the road routed further east, along the edge of the county land rather than through the Aldwell fields, and that the routing change would cost him nothing and benefit the Aldwell farm materially. He said he was prepared to make this happen in exchange for a conversation, a genuine one, about the water rights on Greyfall Run, not a transfer and not a boundary adjustment but an agreement, a formal written agreement about usage rights in dry seasons that gave both properties what they needed. Patience listened to this and understood that it was a genuine proposal, the first genuine one he had made to the Aldwell family in 4 years, and that the genuineness of it was itself significant, because it meant he had concluded that the approach of attempting to take what he wanted was going to cost him more than the approach of negotiating for it. She had produced this conclusion in him through 4 years of defending the Aldwell position, with sufficient effectiveness that the cost-benefit calculation had shifted, and the shifting of it was exactly what she had been working toward. She said she would discuss the water rights agreement with William and with Hartley and would respond within the month. The agreement was reached in the spring of 1737, a formal written instrument that specified the usage rights on Greyfall Run during dry seasons in terms that were equitable to both properties, registered with the Colonial Land Office in Williamsburg, with Hartley present to ensure the registration was procedurally impeccable in every particular. Gray used his committee influence to have the road routed east of the Aldwell fields. Both sides received what they needed. The boundary remained where it had been since 1715. It was not a victory in the complete sense. Patience did not think of it as a victory. She thought of it as the establishment of a stable condition, which was more valuable than a victory, because a victory was a moment, and a stable condition was a foundation. And what she was building required a foundation more than it required any single moment of triumph. What she was building was this. In the years of the contest with Gray, she had been learning not only about the specific legal and economic geography of Greyfall County, but about its broader possibilities. The spaces within the colonial system where a woman of intelligence and patience and sufficient resources could not escape the limitations of her legal position, because the limitations were real, and she was not naive about them, but operate at the edges of them in ways that accumulated over time into something substantial. She had been watching the county's merchant trade, the movement of goods between the farms and the port at Hampton Roads and the merchants in Williamsburg, and she had been watching it with the specific attention of someone assessing it as a landscape to navigate rather than merely to observe. In 1739, at the age of 28, Patience Aldwell married a man named Thomas Carr. This requires explanation, because the marriage, seen from the outside, looks like the end of the story she had been writing, the moment at which she became a femme covert and everything she had built passed into her husband's legal control. This is what the law required. This is what happened to every woman who married in Greyfall County, in Virginia Colony, in the entirety of British colonial America. It is not what happened to Patience. Thomas Carr was 32 years old, a merchant's agent who worked the tobacco trade between Greyfall County and the Hampton Roads port, and who had, over 5 years of working in the county, developed a reputation for absolute reliability in his handling of other people's money, which was the most specific and most valuable reputation a man in his position could have. He was not wealthy. He was not connected. He was the son of a carpenter from Norfolk who had educated himself through the specific method of working for people who knew more than he did and paying close attention to everything they did and said. He was a man of genuine intelligence and genuine honesty, and a quality that Patience had been watching for in the men around her for years without finding it in sufficient concentration, until she found it in Thomas, which was the quality of a man who is entirely secure in himself, and therefore does not need to diminish other people to feel large. She had been corresponding with him on matters of tobacco trade for 3 years before she entertained the idea of marrying him, and the correspondence had given her a detailed understanding of who he was, not the social performance of who he was, but the actual person, the way he thought about problems, and the way he treated the people he worked with, and the specific honesty of his accounting, which was the kind of honesty that is not performed for observers, but is simply the way a person does things when no one is watching. She had also, in the 2nd year of the correspondence, raised with Hartley the question of a prenuptial agreement, a legal instrument that was not common in colonial Virginia, but was not without precedent, which would specify the terms under which the trust income and the business interests she had built over 8 years would be managed after marriage, in terms that gave Thomas full legal access as required by coverture, while including provisions that protected her ability to continue operating the commercial relationships she had established. Hartley had required some convincing that this was achievable in legal form. She had provided the convincing through the specific cases and precedents she had found in her years of legal study, and Hartley had drafted the agreement with the meticulous care of a man who understood that what he was drafting was unusual and needed to be bulletproof. Thomas had read it, asked 2 specific questions about its implications, received her answers, and signed it without negotiation, which was the moment she decided she had been right about him. They were married in November of 1739. She became Patience Carr in the law's eyes. In her own eyes she was Patience Aldwell Carr, which was not a legal designation but was an accurate one, and she used both parts of it in every context that permitted it. In the years that followed, working alongside Thomas in the tobacco trade rather than through him, and with him rather than behind him, she built what the trust income and the lending relationships and the legal knowledge had been the foundation for. She was not, by the law's definition, conducting business in her own name. She was, by every practical measure, the primary strategic intelligence behind what became, over the next 15 years, one of the more successful merchant operations in Greyfall County's trade with the coastal ports. She expanded the lending operation, through Thomas as legal agent, into something that functioned as a small private lending house. providing short-term capital to tobacco growers in the weeks between planting costs and harvest, income at rates that were fair by the standards of the alternatives, and that created, farm by farm, year by year, a network of financial relationships across the county that was as comprehensive as anything Cornelius Gray had built through his 3 decades of land acquisition and legal influence. The difference was that her network was built on genuine service rather than on the extraction that was Gray's preferred method. And networks built on service are more durable than networks built on extraction, because the people in them have a reason to maintain them rather than merely an inability to exit them. He gave them to her with the slightly distracted air of a man who has other things on his mind, and who does not expect his sister to have opinions about land surveys. She took them to her room and spent the evening with them, and the candle burning low on her desk, and her father's copy of the county land records that she had taken from his study the day after the funeral, and kept in her room ever since, going through them with the focused attention she gave to everything that mattered. She found the discrepancy in 3 hours. The documents Gray had produced were not forgeries. They were genuine documents, properly signed and sealed and registered. What they represented was a survey conducted in 1712, before Robert Aldwell had purchased the western portion of the farm in 1715. The 1712 survey had indeed placed the boundary 15 feet east of where it currently stood. The 1715 purchase, however, had included a boundary adjustment, documented in the deed of purchase and registered at the Colonial Land Office, that moved the line to its current position. Gray's documents were real. They simply predated the adjustment, and therefore did not represent the current legal boundary. A man who had spent less time with the county records than Patience had spent in the 3 months since her father's death might not have known about the adjustment. Cornelius Gray, who had spent 30 years with those records, and whose family had been involved in land transactions in Greyfall County since 1670, absolutely knew. She told William the next morning, clearly and specifically, what she had found. She showed him the deed of purchase from 1715, the boundary adjustment clause, the registration number, the precise legal language that established the current boundary as the correct one. She told him what Gray was doing and why he was doing it, and what the 15 feet represented in terms of the water rights on Greyfall Run. She told him all of it without anger and without drama, in the plain, sequential way of a woman presenting evidence, because evidence presented plainly is more persuasive than evidence presented with emotion, and she needed William to be persuaded fully and quickly. William listened to all of it and was quiet for a long time, and then asked how she had found the 1715 deed. She said she had been reading the county records since their father died. She said their father had taught her to read them, which was not entirely true. He had taught her to read everything, and the county records were included in everything. But it was true enough for the purpose. William said he would tell Gray that the boundary was not available for adjustment. Patience said she would like to be present when he did. She was not present. William went to Gray's hall the following week and delivered his refusal, and Gray received it with a graciousness that William found reassuring, and that Patience, when William reported it to her, found entirely alarming, because a man of Gray's character who accepts a refusal graciously has not abandoned the goal. He has simply decided to use a different route. The different route appeared 6 months later in the spring of 1733 in the form of a marriage proposal, not to Patience, to Margaret. Margaret was 19 years old, pleasant and kind, and possessed of a genuine sweetness of character that had always made her the easier of the 2 sisters to be around, and the less easy to protect, because the qualities that make a person pleasant to be around are the same qualities that make them susceptible to approaches from people who understand that pleasantness can be managed. Cornelius Gray was 45 years old and a widower and the most prominent man in Greyfall County, and he proposed to Margaret Aldwell with all the ceremony and consideration that his position made available to him, calling formally on William, and presenting his suit with the specific dignity of a man who understands that the form of a thing matters as much as its substance. William was uncertain. He was not a man who would have sold his sister for social advancement, but he was also a man who understood what a connection to Gray's family would mean for Whitfield Farm's position in the county, and he was 23 years old and managing a property and trying to establish himself. And the weight of Gray's standing was real and present in a way that made the uncertainty genuine rather than merely polite. Margaret was not consulted. This was not unusual. This was the law and the custom and the entire structure of the world she lived in, and Patience understood this, and it was what made what she did next necessary. She went to see Cornelius Gray herself. This was not done. A woman did not call on a man of Gray's standing uninvited, without chaperone, to discuss a matter of family business. It was so far outside the established behavior of women in Greyfall County in 1733 that Gray's housekeeper, when Patience presented herself at Gray's Hall on a Wednesday morning, simply stood in the doorway for a moment without speaking before finding enough presence of mind to show her to the receiving room. Gray came in 10 minutes later with the expression of a man who is concealing his surprise behind the architecture of his authority, and finding the concealment somewhat effortful. He sat across from her and waited for her to explain herself. She said she had come to discuss his proposal to her sister. She said she wanted to understand his intentions directly rather than through the intermediary of her brother, who she respected but who did not know what she knew. She said this without apology and without the performed deference that he clearly expected, and that she had decided, on the walk to Gray's Hall that morning, was something she was never going to give him under any circumstances whatsoever. Gray was quiet for a moment, and then said that her brother was the appropriate person to discuss the matter with. She said she agreed that William was the appropriate person for the formal discussion, but that she was the appropriate person for the present one, because the present one was about the water rights on Greyfall Run and the 1715 boundary adjustment, and the 1712 survey that he had produced to William the previous autumn, and those were topics that William did not yet know as well as she did. The quality of silence that followed this was different from the silence that had preceded it. It had a different texture, a different weight. Gray looked at her for a long moment, and she held his gaze with the steadiness of a woman who has prepared for this moment and knows that the preparation is sufficient. He said she was direct. She said she was her father's daughter. What happened in the next hour of that conversation in Gray's receiving room was the first move in a contest that would last 20 years, and it was Patience who had chosen the ground and the timing and the terms of the engagement, which meant that whatever Gray had expected from a 22-year-old woman calling on him uninvited on a Wednesday morning, it was not this, and the fact that it was not this was the first and most important advantage she had. She told him plainly that she understood what the proposal to Margaret was intended to accomplish. She told him that Margaret's trust, administered by William under their father's will, would not pass to Gray upon marriage because the trust's terms required William's consent for any disbursement to a spouse, and that William would not give that consent if she advised him not to, which she would. She told him that the boundary question was settled by the 1715 deed, and that she had registered a copy of that deed with the Colonial Land Office in Williamsburg the previous week, which she had done precisely so that it could not be quietly removed from the county records, which she had understood from the beginning was a risk. She told him all of this, and then she stopped talking and let the silence sit, and watched his face with the complete attention of a woman who has read faces all her life and knows exactly what she is looking for. What she saw was not the anger she had expected and prepared for. What she saw was something more complex than anger, a reassessment, a man recalibrating his understanding of the terrain he was operating in because the terrain had turned out to contain features he had not mapped. It lasted only a moment. Then the authority came back over his face like a shutter closing, and he said that she was making assumptions about his intentions that were not warranted. She said she hoped she was wrong. She said she hoped his proposal to her sister came from genuine regard, and that he would be a kind and faithful husband to Margaret if she chose to accept him. She said she had come not to refuse his proposal on Margaret's behalf, which was not her right to do and which she would not presume to do, but to ensure that he understood that the Aldwell family's interests were known and documented, and not available for quiet acquisition through the mechanism of marriage. She said that if his regard for her sister was genuine and his intentions were honorable, she welcomed the connection and would say so to William. She stood up, which indicated the conversation was over, which it was not proper for her to indicate, because ending a conversation was the prerogative of the host and not the visitor, and she did it anyway. She walked back to Whitfield Farm and told William that evening that she had visited Gray and what she had said, all of it, without omission. William's response moved through several stages, beginning with something close to alarm at what she had done and ending, after an hour of conversation, with a quieter and more considered reaction. The reaction of a man who has just understood that his sister knows things about the situation he is in that he should also know, and that the knowing of them changes the situation considerably. Margaret did not marry Cornelius Gray. He withdrew the proposal 6 weeks later, citing unspecified reasons, and Margaret, who had been uncertain about it from the beginning, and had said so to Patience in the privacy of the room they shared, received this news with the specific relief of a woman who has been released from a danger she only partially understood. Patience received it with the understanding that the withdrawal was not a retreat but a repositioning, that a man of Gray's character and resources did not abandon goals. He revised strategies, and that the revised strategy would come, and she needed to be ready for it when it did. She spent the next 3 years preparing. The preparation had several components, and she pursued each of them with the systematic patience of a woman who has decided that the distance between where she is and where she needs to be is crossable, but requires work that cannot be rushed. The first component was legal knowledge. She wrote to an attorney in Williamsburg named Mr. Francis Hartley, a man her father had used for the registration of documents, and whose name appeared in the county records as a competent and thorough practitioner, and she engaged him as an advisor on matters pertaining to women's legal standing in the colony of Virginia. She paid him from the income of her trust, which William administered faithfully, and which gave her a modest but real financial independence. And she asked him specific questions in specific letters, and received specific answers that she read and reread and built into her understanding of the legal landscape, with the thoroughness of someone constructing a map of terrain they intend to navigate. She learned about coverture and its limits. There were limits, not many and not easily reached, but they existed in the specific provisions around feme sole trading status, available to married women who conducted business independently of their husbands in certain colonial jurisdictions, and in the provisions around trusts and entailed property that her father had partially used, and in the narrower provisions around widowhood and dower rights that gave a woman a specific and protected claim on a portion of her husband's estate that could not be entirely alienated even by the husband's will. She learned these limits with the attention of a woman who is not studying for an examination, but is studying for a purpose, and the purpose gave her study a precision that examination preparation rarely produces. The second component was economic. Her trust income was modest, but she used it with a discipline that turned modest into something more than modest over 3 years of careful application. She lent small amounts, through William as her legal agent, to 2 families in the county who needed bridge capital for specific improvements, and who paid back with the reliability of people who had received help and understood its value. The amounts were small. The relationships they created were not. She was building, 3 years before she knew exactly what she would need it for, a network of people in Greyfall County who owed her something, and who knew that the debt was owed to her specifically, even if the legal form of the transaction had William's name on it. There is a particular kind of power that announces itself with noise, with the volume of a man who has learned that the people around him will move out of his way if he is loud enough and certain enough, and sufficiently consistent in his expectation of deference. It is the most visible kind of power and therefore the most commonly recognized. And because it is the most commonly recognized, it is also the most commonly misunderstood. Because volume and certainty and the expectation of deference are not power itself, but only its performance. And a performance, however convincing, is not the same as the thing it represents. The most powerful person in any room is not always the loudest. Sometimes the most powerful person in the room is the one who has spent 20 years learning everything there is to know about the loudest person's weaknesses and has been, with extraordinary patience and extraordinary precision, waiting for the right moment to use that knowledge. Her name was Patience Aldwell. The name was her father's choice, made at her birth in 1711, in the reasonable expectation that a woman named Patience would embody the quality, and she had, though not in the way her father had intended. The patience she developed was not the patience of a woman who accepts what is given to her and waits quietly for whatever comes next. It was the patience of a woman who understands that the distance between where she is and where she intends to be is real and must be crossed at the pace the crossing requires, without rushing, without revealing the destination, without giving the people between her and where she is going any reason to move from where they stand before she is ready for them to move. She was born at Whitfield Farm, a property of 240 acres in Greyfall County, Virginia colony, the eldest of 3 children of a man named Robert Aldwell, who had come to the colony from England in 1703 and had built over 28 years of tobacco cultivation and careful land management, something that was not a great estate by the standards of the colony's grandest families, but was a genuine and solid accumulation, land that was paid for and productive, a house that was maintained and comfortable, a reputation in the county that was the reputation of a man who dealt honestly and worked hard and kept his word. Robert Aldwell was not a rich man by the measures of Greyfall County's upper tier, but he was a man of substance and of standing, and what he had built with the intention of leaving it to his children. The law of Colonial Virginia in 1731, the year Robert Aldwell died, had specific and detailed opinions about the leaving of property to children, and those opinions differentiated sharply between male children and female ones. Under the doctrine of coverture, which the colony had inherited from English common law and applied with the thoroughness of a legal system that had not yet been asked to examine its own assumptions, a woman upon marriage became legally subsumed into her husband, ceased to exist as an independent legal entity, and could not own property, enter contracts, bring suit, or conduct any legal transaction in her own name. What she brought into a marriage became her husband's. What she might have inherited became her husband's. She was, in the precise language of the law, a feme covert, a covered woman, covered by her husband's legal identity and therefore invisible beneath it. Robert Aldwell knew this law as well as any man in Greyfall County. He had lived under it for 28 years and had seen what it did to the women around him, had watched the daughters of men he respected reduced to the legal equivalents of furniture at the moment of their marriages, their fathers' careful accumulations dissolved into their husbands' estates without remainder. He had 3 children. His son William was 22 years old, capable and steady and entirely trustworthy in the way of a young man who has grown up watching a father worth emulating. His daughters were Patience, 20 years old, and Margaret, 17. He loved all 3 of them with the uncomplicated completeness of a man who has not had sufficient leisure to be ambivalent about anything, and he understood, with the clarity that approaching death sometimes provides, that the law as it stood would give William everything and give his daughters whatever their future husbands decided to give them, which was not the same thing as giving them anything at all. He wrote his will in the last weeks of his life with the specific intention of doing what he could within the law's limits. He left the farm to William outright, as the law effectively required. He created, within the will's provisions, a deed of trust for each of his daughters, a legal instrument that was not yet standard practice in Greyfall County, but that was recognized in Virginia law, which placed a portion of the farm's value in trust for Patience and Margaret specifically, administered by William as trustee, with the provision that the income from the trust could not be accessed by any future husband without William's consent as trustee. It was not a perfect protection. It was the best protection available to a man who understood the law well enough to know its limits and cared enough about his daughters to push against those limits as far as they would go. He died in March of 1731. William became the master of Whitfield Farm. Patience and Margaret became women with trusts administered by their brother, which was a form of security that depended entirely on their brother's continued willingness to administer it faithfully, and which Robert Aldwell had structured on the correct assessment that William was a man whose faithfulness in this regard was not in question. The man who became the question was not William. His name was Cornelius Gray. He was 43 years old in 1731, a man of the largest estate in Greyfall County, 480 acres of prime tobacco land in the center of the county plus an additional 160 acres of timber and pasture to the north. A man whose family had been in the colony since 1670 and whose name was on more documents, more deeds, more legal instruments, and more county records than any other name in Greyfall County's history. He was a magistrate, he was a vestryman, he was a member of the county committee that decided road placements and boundary disputes, and the 100 other practical questions of colonial administration that sound unremarkable and are anything but, because the man who controls where the roads go and where the boundaries fall controls, in practical terms, much of what the land around him is worth and who is able to use it. He had been married once, to a woman named Eliza who had died in 1726 after bearing him 2 sons, both of whom survived and were being raised at Gray's Hall, the main house of his estate, by a succession of female relatives whose willingness to perform this service was not entirely unconnected to the economic consequences of refusing a man of Cornelius Gray's standing in Greyfall County. He had not remarried in the 5 years since Eliza's death, which was noted by the county's social observers as a departure from the expected pattern, and attributed variously to grief, to the sufficiency of female relatives as household managers, and to the possibility that a man of Gray's position was taking his time in selecting a second wife, because the selection had implications beyond the domestic. What Cornelius Gray wanted in 1731 was the Aldwell land, not for its size, which was modest compared to what he already held, not for its tobacco production, which was good but not exceptional. He wanted it because it sat on the western side of a creek called Greyfall Run, which was the boundary between his southern fields and the Aldwell property, and which had been, for the 20 years since his southern expansion had brought him to that boundary, a source of persistent minor frustration in the form of water rights. The creek ran through the Aldwell land before it reached his, and the Aldwell family's use of it for their irrigation and their mill operation reduced the water available to his southern fields in dry seasons in ways that were not catastrophic but were annoying. And Cornelius Gray was a man who did not tolerate annoyances when the means of eliminating them were available. The means were available. Robert Aldwell was dead. William Aldwell was 22 years old and had inherited a farm he was fully capable of running, but had not yet had the time to understand in the full depth that his father had understood it, had not yet developed the specific knowledge of the county's legal and social geography that would have told him what the interest of a man like Cornelius Gray in his western boundary actually represented. William was not naive. He was simply young, and young men in Greyfall County in 1731 who found themselves in a property dispute with Cornelius Gray were at a disadvantage that youth did not help. The approach Gray used was the approach of a man who understood that the most efficient way to acquire something is to make the person who has it want to give it to you. He began with friendship. He called on William Aldwell 3 weeks after Robert's funeral, with the specific warmth of a man extending condolences and offering the support of an experienced neighbor to a young man newly responsible for a substantial property. He was helpful in the specific ways that a magistrate and county committee member could be helpful, smoothing a minor road access question that had been pending in William's favor, providing an introduction to a merchant in Williamsburg who bought tobacco at better rates than the factor William had been using. He was present, useful, and generous in a way that William, who had grown up watching his father speak well of Gray as a man of standing if not of warmth, found entirely natural. Patience watched all of this from the beginning. She was 20 years old and unmarried, living at Whitfield Farm with William and Margaret, and managing the household with the competence her mother had left her when she died 4 years before of a fever that had moved through Greyfall County that summer with the thoroughness of something that does not distinguish between the deserving and the undeserving. She had her mother's practicality and her father's precision, and something additional that was entirely her own, a quality of observation so complete and so disciplined that she rarely missed anything happening in the social and economic world immediately around her. She had developed this quality not from any formal instruction, but from the specific education of a woman who has understood since early adolescence that the world she lives in has decided she is not important enough to conceal its workings from, and that this assumption, which is intended to diminish her, is actually the most useful thing the world has ever given her. She watched Cornelius Gray visit William. She watched the pattern of the visits and the content of the conversations and the way William's posture relaxed over the months of the friendship, and the way Gray's eyes moved across the farm's land whenever he stood on the property, the specific quality of attention of a man assessing something he intends to own. She watched and she noted and she said nothing to William, because William was not yet ready to hear what she would have said, and saying it too early would only have made him defensive and reduced her ability to say it effectively when the moment came. The moment came in the autumn of 1732, when Gray made his first formal approach to William about the western boundary and the water rights. He framed it as a neighborly adjustment, a minor redrawing of the boundary line to bring it into alignment with what he described as the original survey, which had been, he said with the authority of a man whose family had been in the county longer than anyone else's, slightly mismarked in the Aldwell family's favor. He produced documents. The documents were, to a man who had not spent years studying the county's land records, entirely convincing. They bore the signatures of county surveyors from 20 years before and the official seals of the Colonial Land Office, and they described, in the precise language of official documentation, a boundary line that was 15 feet west of where the Aldwell family had always understood the boundary to be. 15 feet was not a catastrophic loss. Gray was too skilled to ask for something so large that it alarmed. 15 feet along the western edge of the Aldwell property, however, included the bank of Greyfall Run on the Aldwell side, and control of that bank gave Gray the ability to manage the creek's flow in the dry season in ways that the current arrangement did not. The 15 feet was the point of the entire exercise. William, who had not seen this coming and who was standing in the kitchen of Whitfield Farm looking at documents produced by the most powerful man in the county with the air of a man who does not want to give offense, said he would need to think about it. That evening, after Gray had gone, Patience asked William if she could see the documents.